I would like to welcome everybody to today's online research seminar. This enacts a series of online research seminars offered by the School of Law and the Cyprus Center for European and International Affairs of the University of Nicosia. Dimitrios Kourtis will present his research focusing on transitional justice in post-war societies, Greece, after the end of the Second World War. Dimitrios is a PhD candidate at the School of Law, the Aristotle University of Thessaloniki, and a research associate and adjunct instructor at the School of Law here at the University of Nicosia. Dimitrios, you may begin.
Thank you, Andreas. Thank you, everyone, for being here and, let's say, contribute to this project, which is a project that has recently started, a project that I'm working regarding primary sources and primary research for the past 5 or 7 years. So I will begin sharing my presentation with you, and hopefully we will have a fruitful discussion. Well, let me maximize the presentation. So here you can see the title. As Andreas said, it's Transitional Justice in Post-War Societies, Greece after the end of the Second World War. And now moving to the research outline. The scope of this research is, hopefully, to analyze, explicate, and describe the legal contour of Greece's policies regarding the so-called jus post bellum, law after the end of the war, including post-war justice, the so-called transitional justice, we're going to define the term later on, and remedial measures of pacification. The present project aims at applying transitional justice, for short TJ, doctrines, and especially the theory on the genealogy of transitional justice, coined as both a term and a doctrine by Ruti Title, a great professor of transitional justice, to the processes and legal political choices of Greece's governing elites during the after-war period while dealing with the wartime atrocity crimes and questions of reparation and rehabilitation. Let us now check some framework, some questions that, let's say, establishing the framework of the research. Was there a specific goal regarding the post-war justice project launched by the Greek authorities? And also, how can we accommodate Greece's efforts to the concept of TJ genealogy? Is Greece's policy choices linked with the classical doctrine of jus post bellum or jus victoriae? Were Greece's policy and legal choices in line with its internationally assumed obligations? Was Greece affected by the early Cold War bifurcation and stalemate? And how should we assess the terms of the this effort, on terms of TJ or international law? Was the project successful regarding transitioning from a state of war to a state of pacification and normality of institutions? If not, should we regard Greece as a society/state in a prolonged state of transition with a truncated justice project? Moreover, which are the legal implications arising from such a classification? Also, is the rise of neo-Nazi and neo-fascist ideologies somehow linked to the prolonged or unsuccessful transition? And finally, how Greece might benefit from contemporary TJ doctrine and praxis so as to remedy, repair, and rehabilitate past atrocities. Let us move now to the next slide. Methodology outline, and hopefully understanding the challenges of the research. In terms of bibliographic review, we need to, let's say, have a view of TJ scholarship, also about scholarship about atrocity crimes, about punishment, about reparation, the concept of remedial justice, and the concept of civil society transitioning. We need to study also, let's say, topics of war studies, of course, the history of Greece before, during, and after the tripartite occupation of the Axis powers, including Greece's, let's say, troubled past regarding the Holocaust. And also we need to, let's say, incorporate doctrines of international criminal law and its application within the sphere of the national legal order. Seminal points of bibliographic reference. We have to, let's say, discuss Drumble's thought about on atrocity punishment in the national law.
Thank you very much. Thank you.
We need to, let's say, check Hagen Fleischer's The Wars of Memory. Also, Katerina Kralova's In the Shadow of Occupation is a seminal work, a seminal bibliographic reference, which basically fueled my study. including Dimitrios Kourtis' collaborationist trials, a book basically, let's say, establishing the scholarship on this particular aspect of transitional justice. Of course, we need to pay, let's say, our tribute to Professor Mazauer and his edited volume about entitled "After the War Was Over: Reconstructing Family, Nation, and the State." And basically, we wouldn't have this presentation today without rooted titles, Transitional Justice, published in 2000. Let us now check what do I mean when we are referring to TJ genealogy. This is basically a doctrinal effort, a scholarship effort to link transitional justice to the classical, let's say, doctrines of international law, namely jus post bellum and jus victoriae. The law for the termination of the war or for after the war, and the law of the victorious party, the law of the victory. Such, let's say, doctrines can be traced back to, let's say, the forefathers of international law, Francisco de Vitoria, Alberico Gentili, Ugo Grotius, and Emeric de Vatel. Regarding primary sources, we need to focus on a very, very vast amount of archival material, including judgments, indictments, diplomatic correspondence, and post-war reports. Let us now turn to the challenges regarding, let's say, the process of assessing the primary sources. We basically have a panspermia of archival materials unevenly distributed between private collections, Greek public authorities, German institutions, and several entities headquartered in the territories of the formerly victorious powers of the Second World War, including the United States, the United Kingdom, and of course the former USSR, nowadays Russian Federation. The official archives of the National War Crimes Bureau, the Ethnicography Εγκλημάτων Πολέμου, were basically mashed into paper pulp and utterly destroyed as per a ministerial decision dated 16th of July, 1955, without prior notification given to the custodian of the archives, the public prosecutor of the Court of Appeals of Athens. So we basically lack the fundamental, the quasi-constitutional archival material of this research, because we are basically discussing the mandate of the National War Crimes Bureau. Anyway, the author, that's me, has extensively documented during the past 7 or 10 years atrocities described in civil suits and civil actions filed before Greek courts against the Federal Republic of Germany. However, their evidentiary and probative value is basically disputable because, as all lawyers know, some things are not exactly and precisely, let's say, outlined in a legal remedy, in a civil action, or in a civil suit. Anyway, let us move now to our next PowerPoint, to our next slide. Moreover, I was lucky enough to have been granted access to eyes-only top-secret reports, including the report of the Γενικό Λογιστήριο του Κράτους, the General Accounting Office of the State, and the relevant report of the Νομικό Συμβούλιο του Κράτους, the Legal Council of State. This is, of course, Greek authorities, Greek institutions, and the Greek Ministry of Culture and Sports, Υπουργείο Πολιτισμού και Αθλητισμού, inventory of looted or stolen cultural treasures. However, all these secondary sources heavily rely on, first, further secondary sources, basically the so-called Doxiadis report on the sacrifices of Greece during the Second World War. It was drafted between May 1941 or November 1944 under the supervision of the well-known Dr. Konstantinos Doxiadis, an architect and urban planner. Later on, the report was published in Athens in 1947, I think, by the Ministry of Reconstruction. This was an early post-war Hellenic ministry. Moreover, archival materials not available to the average researcher and or materials inaccessible in general. Basically, both the GAO and the LSC in the reports cite a vast amount of primary sources that were never actually studied by the drafters. This has been confirmed by relevant persons, by relevant authorities, by relevant officials, basically, let's say, engaged in the drafting of the reports. They have basically cited several primary sources, copying them from other secondary sources like the Doxiadis report and so on. And the third and most problematic, let's say, assumption is point is that these reports are grounded upon firmly established assumptions, like the fact that interstate reparations or the forced loan do not affect private interests, and or the general interest of justice within the framework of a holistic TJA policy. Adding, let's say, insult to injury or complicating the situation even more, judgments, indictments, pre-trial decrees or orders, called voulevmata in Greek, regarding post-war atrocity crimes are held under the authority of the local courts of appeal in Greece. This is the court of appeal in Athens, Larissa, Thessaloniki, Ioannina, and so on. Basically, we are not certain where these files can be located in different CAs, in different court of appeals. But the average situation for the researcher is that we have to face the lack of digitalization, the inexistence of an open science policy, and basically access to the state archives is more or less, if they can be traced, of course, is more or less conditional upon the willingness of each CA head and especially of each public prosecutor, let's say, serving in the corresponding CA. Basically, in certain instances, I have faced even personal data protection laws being cited to, and I have been denied access to the archives to court. So let us now move to something more interesting. This is, let's say, the substance of this presentation. You have been, let's say, you have heard about TJ genealogy and the concept of TJ. Let us give a functional or operative definition of TJ. It is a set of mechanisms, institutional arrangements, legal, social, political instruments, aiming at safeguarding the transition of a given society from a state of illegality, flagrant breaches of fundamental rights, and juridical socio-political anomaly to a state of pacification, normality, and re-establishment of the rule of law. Basically, transitional justice can be better understood through the so-called four-square cipher of TJ. Transitional justice aims at truth-seeking, institutional reform, of course, prosecutions, and reparations. Let us now move to TJ genealogy. According to Professor Title, we have basically three phases in TJ genealogy. The first phase between the end of the Second World War and the 1950s, let's say the culmination of the Cold War. The second phase between the 1970s, of course, it is the 1970s for states in the global north and especially in Central and let's say South America, but not for Europe. 1989 is the D-Day or the fundamental year for transitional justice in Europe after the collapse of the USSR and the satellite powers. And the second phase basically extends until 1999. The third phase supposedly is still ongoing from 2000 onwards. The basic characteristic of the phase of the first phase is that it's highly affected or impacted by the so-called prehistory of TJ genealogy. This is the doctrines and praxis of 15th and 16th century jus victoriae. The principle of moderation established in the 17th and 18th century. Also, the positivistic doctrines or the jus voluntatis, voluntas facit jus, the will of the state creates the law of the 19th century, and of course the two court treaties, let's say, permeating the first decades of the early of the 20th century. This is the Covenant of the League of Nations and of course the Versailles Treaty. Anyway, let's now turn to what we mean when we are discussing this famous jus victoriae. Basically, if we are medieval canon lawyers or civil lawyers or even medieval lawyers focused on the law of nations, if we had utriusque juris peritia, if we knew both canon law and Justinianian civil law, we will be very, very familiarized with the question of jus victoriae. Jus victoriae is the power of, let's say, the winning commonwealth to restore justice against the losing commonwealth. But we can understand what jus victoriae actually is by looking in this chart. Hopefully, it is more or less, let's say, self-explanatory. Commonwealth A is the commonwealth that vindicates its own right and wants the rest. The rest or the thing is something that has been stolen or that has been, let's say, taken away, or a right that has been violated by the claimant state. the Commonwealth A or the state A, the civil polity A in this example. So Commonwealth A, having been offended vis-à-vis the rest by Commonwealth B, first acts as the claimant, raises a claim in order for the restoration, to restore justice, to restore the legal order, and to vindicate the rest. When Commonwealth B refuses, then the very same claimant becomes the law enforcer. It pursues a just war against Commonwealth B. It waves a just war against Commonwealth B in order to restore the rest. So the Commonwealth B, from being a defendant, becomes a law offender. And finally, when hopefully Commonwealth A defeats Commonwealth B, then Commonwealth B becomes the losing litigant, while Commonwealth A becomes the judge in a flagrant violation of a today well-established principle in international adjudication, that no one can be a judge of his own matter, his own thing, nemo iudex in res sua in Latin. So basically, when Commonwealth A has been victorious and it has, let's say, won the war against Commonwealth B, then Commonwealth A acts as the judge. And that's when jus victoriae comes into play. Being the judge of itself against Commonwealth B, Commonwealth A was legally obligated during the medieval era to, let's say, retrieve the res or vindicate the res and retrieve the costs of the litigation, in inverted commas, the so-called litigation, which in this case was the so-called force shoot. So war basically was regarded back then as a legal remedy from a commonwealth that has the right to the res against the commonwealth that has violated the res. Let us now move to our next slide. So according to these doctrines, these early medieval doctrines, Victoria added nothing to the rights or obligations of the parties. It was merely a legal remedy, or basically the result of the exercise of a legal remedy regarding the vindication of the res and the end of the just cause of the war. As the forefather, the great theologian Francisco de Vitoria, aptly pointed out in his Relectio Posterior on India about the Indians lately discovered. This was, of course, about the indigenous American populations. He points out that the victor must think of himself as a judge sitting in judgment between two commonwealths, on one the injured party and the other the offender. He must not pass sentence as the prosecutor, but as a judge of his own or of its own cause, of course. He must give satisfaction to the injured, but as far as possible without causing the utter ruination of the guilty commonwealth. Alberico Gentili, he was basically an early genius of international law, the law of nations, in his seminal volume on the law of war of 1598, and Hugo Grotius, the father proper of international law, in his seminal volume, the Iure Bellia Pacis on the law of war and peace, subscribed exactly to this view about the so-called civil shoot or force shoot formula. Let's say, the father of the contemporary notions of international law. We discussed them in our classes and auditoria until nowadays, until today. Emeric de Vattel basically grounded the jus victoriae on the concept of self-defense and reasonable security. So the victorious power should, let's say, cause only proportional injury to the defeated party. Jean-Jean Bourlamaqui, in his The Principles of Natural and Politic Law, also points out that unjust treaties, this is of course peace treaties, cannot be justified based on the jus victoriae. This is another way to say that the victorious power cannot force the defeated party into a Leonine treaty, as we used to refer to them in, let's say, the standard lingo of international law. However, in the beginning of the 20th century, when positivism was almost the word of God in both international law and domestic law, the Permanent Court of Arbitration, in a highly, let's say, forgotten case, the Venezuela preferential case, basically decided that the jus victoriae was unlimited, because basically Venezuela defaulted its payments, and then three powers Great Britain, Germany, and Italy waged a war against Venezuela and imposed a naval blockade. Then Venezuela executed a protocol with the blockading powers and gave them preferential rights, preferential powers regarding the repayment of the loans. And the PCA said basically that when the protocol has been executed, when the protocol has been signed, no matter what happened before, no matter what the victorious powers should have done vis-a-vis the defeated power, the preferential rights exist. And so Great Britain, Germany, and Italy have to be repaid on a preferential status. Anyway, the Treaty of Versailles of the 26th of June of 1999 tried to, let's say, revitalize the whole discussion about the jus victoriae by separating and drawing a red line, a definite line between the so-called penalties and the reparations. You can check the articles in the relevant parts of the Versailles Treaty. Anyway, let us now turn to the state of play before, immediately before the outbreak of the Second World War. Basically, we have, well, let's say, two lines of thought mirrored in the Versailles Treaty. First and foremost, we have penalties because we were trying to penalize the war. This is the so-called Kaiser Clause, the Article 227 of the Versailles Treaty, basically publicly arraigning the former Kaiser on a supreme offense against international morality and the sanctity of treaties. In the part of the Versailles Treaty where restitution was regulated, we have the so-called war guilt clause, Article 231. You can read the wording. You can read the wording of the war guilt clause. The Allied and associated governments affirm, and Germany accepts the responsibility of Germany and her allies, etc., etc. And basically, this was considered the foundation, the fundamental notion, the war guilt clause of reparations. And basically, this mirrors the understanding of the jus victoriae and the understanding of the just war theory. Basically, they needed Germany to accept guilt and the totality of guilt for the First World War in order for the war to be considered, for instance, a just war, in inverted commas, and then restitution and reparation follow short after based on the just cause of the Allies, of the entente cordiale. Anyway, afterward justice was left to the reserve domain, was left to the jurisdiction of the interested states, basically Germany and the Ottoman Empire, and later on Turkey. And this proved highly ineffective. We have, let's say, the Leipzig trials of 1921 and the Istanbul mock trials of 1929, sorry, of 1919 and 1920. They were ineffective and they paid a lip service to justice. Basically, later on, Article 19 of the League of Nations Covenant basically tried to formulate, let's say, and reinvigorate the principles of moderacy, the principles of clemency, and the principles of logic regarding inter alia afterward treaties or treaties of pacification. Article 19 stipulated that the Assembly, this is roughly equivalent to the General Assembly of the United Nations, the Assembly of the League, may from time to time advise the reconsideration by members of the League of treaties which have become inapplicable and the consideration of international conditions whose continuance might endanger the peace of the world. Bolivia was the very first state party that attempted to revise the peace treaty, the treaty that terminated the War of the Pacific of 1904 with Chile. This happened in 1921. China attempted to revise several Leonine treaties with Western powers in 1929. However, France strongly protested the interpretation of Article 19, giving, let's say, the right or giving the faculty to Bolivia, China, and other states to revise peace treaties. France, of course, and French governing elites were fearful of a possible revision request regarding the Treaty of Versailles. Anyway, at the cracking dawn of the Second World War, jus victoriae basically gave its place to demands of logic, clemency, moral moderacy, and basically some kind of proportionality control regarding what the victorious powers can ask, can demand from the defeated powers. Let us now turn to, let's say, the basic concepts of Greece's turbulent journey towards transitional justice. First, some historic information, basically in order to remind you the situation. The occupation of Greece by the Axis forces started in April 1941. The Nazi military forces invaded Greece to assist the fascist Italian troops, which were overpowered by Greek tactical army during the first stage of the war. Greece was simultaneously invaded by Germany's ally Bulgaria from the north, of course, following the excessively brutal Battle of Crete of May 1941. The totality of the Greek territory was placed under the belligerent occupation of the three forces no later than June 1941. In early October 1944, the German and Bulgarian military units were forced to evacuate the mainland due to the pressure exercised by the Allied powers. However, in both Crete and the Aegean Islands, German strongholds were preserved until after the end of the Second World War in Western Europe. The tripartite occupation was characterized by excessive atrocities in the form, especially in the form of armed reprisals against the civilian population, the financial drain of Greece's public treasury and private capital, the utter disrespect for human life, the looting of cultural artifacts and archaeological treasures, the destruction of public infrastructures, and the exhaustion of agricultural and livestock resources, leading to the terrible famine, the so-called Great Famine, between 1941 and 1944. Greece was the only occupied country that was forced to sign a loan agreement with the occupying powers, Germany and Italy, lending them capital to finance their activities and cover the so-called expenses of the occupation. The loan was executed during 1942. Although Hitler himself acknowledged the existence of the obligation to repay, repayment of the loan is of course still outstanding, and currently the debt is estimated to amount to somewhere near 12.55 billion USD. Of course, the economic science has several, let's say, methods of evaluating the loan. This is something we can discuss later on if you like. Anyway, the post-war state of play. Post-war Greece was actually a ruined country. Greece was subjected to enormous destruction of its industry, 80% destroyed. This is official data. This is not something that I'm making up. Infrastructure, 28% destroyed. Ports, roads, railways, and bridges, 90%. There were military targets back then. Forests and other natural resources, 25% destroyed, especially in the north due to Bulgarian and German activities there. And of course, we have a terribly excessive loss of civilian life. According to the official documents submitted to the Allied powers during the Paris Peace Conference in 1946, the country lost up to 19.7% of its pre-war, this is estimations of 1939, population. Comparative research verifies that Greece had the highest death rate amongst the Allies. For instance, the United States of America had a 0.66%, while Yugoslavia had a 13.83%. Almost 11.20% of the civilian population of Greece was either executed during reprisals or starved to death during the Great Famine. Somewhere near 1,700 local communities were targeted with atrocity crimes. We have at least 98 instances of mass civilian murders reported as early as the end of the Second World War hostilities, while a great deal, basically 80% of the Greek Jewish population was exterminated in the German concentration camps, and particularly Dachau and Auschwitz-Birkenau. Human life was not particularly valued during the occupation. Greeks were considered basically racially inferior, non-Aryan, despite the original pseudo-racial estimations of the Nazi masterminds, as attested during the Nuremberg trial of major war criminals. Field Marshal Wilhelm Keitel, chief of the Armed Forces High Command, issued an order dated 19th of September 1941, calling for the shooting of 100 civilian hostages for every German soldier, and the execution, for every dead German soldier, and the execution of 50 civilians for every wounded soldier. Local collaborators worked hand in hand with the occupying powers to ensure both the expropriation of civilian property, basically property of the perished Greek Jews, and the control of the means of production. The Greek population called collaborators, as we all know, dosilogi, meaning the one who will account for his or her actions, because it was common ground and wishful thinking, of course, that they would be called to account for their atrocities after the end of the occupation. Loyalties, as we all know, shifted rapidly after the end of the war. The Greek Civil War followed literally after the end of Greece's occupation between the royalist forces supported by the British government and the communist partisans. This civil conflict, this extreme atrocity, paved the way for the establishment of what has been called by Professor Mazauer, for instance, an institutionalized, and of course, Professor Fleischer, an institutionalized amnesia regarding war atrocities, the demand for persecution and punishment of war criminals, and also, let's say, the justice vis-à-vis local collaborators. Later on, the Cold War ambience and the rapprochement between the rightist Greek government and West Germany consolidated the said amnesia, terminating criminal prosecutions and postponing the final settlement regarding reparations. Let us now move to our next slide. Hopefully, it's less green. The quest for justice. Greece was part of the anti-Axis alliance since October 1940. Greece was also an original signatory of the United Nations Declaration of January 1st, 1940, the basic legal document establishing the alliance against the Axis powers. Greece also signed the so-called St. James Inter-Allied Declaration on German Atrocities of January the 13th, 1942, reaffirming the application of international humanitarian law, the Hague Conventions of 1907, and raising the issue of post-war justice based on judicial proceedings and due process of law. According to the declaration, the Allies place among their principal war aims the punishment through the channel of organized justice of those guilty of or responsible for these crimes, whether they have ordered them, perpetrated them, or participated in them, resolved to see the Allies, that is, tweet in a spirit of international solidarity that those guilty or responsible, whatever their nationality, are sought out, handed over to justice, and just, and B, that the sentences pronounced are carried out. Hold tight on St. James Declaration. It is really important. Greece also adhered to the Big Four's Moscow Declaration on German Atrocities of the dated November the 1st, 1943, where the Allies provided for the compilation of lists in indictments, that is, in all possible detail from all these countries. You can see the countries, the Soviet Union, Poland, Czechoslovakia, Yugoslavia, Greece. We have reference, we have an explicit reference to Crete and the islands, including Norway, Denmark, etc. So finally, Greece adhered to the London Agreement for the prosecution and punishment of major war criminals of the European Axis. This is, of course, the charter of the Nuremberg International Military Tribunal, for short IMT. Per force of a declaration dated September the 10th, 1945, the Greek authorities informed the British government on their intention to be bound by the London Agreement and the IMT Charter. The Charter recognized three typologies of international crimes in its Article 6: crimes against peace, this is the crime of offensive war, war crimes, and crimes against humanity perpetrated within the context or nexus of an armed conflict. Of course, Greece was not part of the London negotiations and was not able to affect or contribute to the establishment of the IMT. However, as we will discuss in the following slide, Greece's case was presented somehow before the IMT. At the dawn of the post-war era, Greece assumed a chain of international legal obligations aiming at the prosecution, punishment of war criminals, and paying justice to victims vis-à-vis local collaborators. Let us now move to our next slide. So the quest for justice and the Nuremberg precedents, although Greek scholarship has lately insisted on the participation of Greek delegates in the IMT as observers, this position, according to my research, is wrong, or at least not verified. And it's not possible to verify it, basically. So somewhat wrong, or a holy scripture. Greece was only represented at the Office of the Chief of Counsel of War Crimes of the United States of America Military Tribunal, seated in Nuremberg, the so-called USNMT. This was the tribunal that was established within the American zone of occupation of post-war Germany after the end of the Nuremberg trial before the IMT. Greece sent a mission of 8 delegates, which were credited at the office of the American prosecutor. The delegates acted also as national observers during certain subsequent trials, and most certainly the so-called hostages trial before the USNMT, which was of particular importance for both Greece and Yugoslavia. The IMT discussed the case of Greece while dealing with the question of the crime of aggressive war and convicted Colonel General Alfred Jodl, Chief of Operations Staff of the Reich's Armed Forces High Command, on counts of conducting aggressive war against Greece. However, war crimes and crimes against humanity perpetrating during the occupation were never discussed, addressed, or adjudicated before either the IMT or the USNMT. The USNMT in the hostages trial dealt with a series of atrocity crimes committed against the civilian population. However, the judgment is highly problematic because it denied the prisoner of war status for the members of the guerrilla or partisan forces of Greek resistance and accepted the legality of massive armed reprisals against civilian hostages, scrutinizing the practice only on the basis of proportionality and the principles stemming from the so-called elementary notions of humanity and justice. Even so, armed reprisals perpetrated by German armed forces in Greece were declared by the USNMT disproportional, excessive, and mere acts of revenge, so they are considered finally unlawful. The judgment set an important precedent, though, regarding the illegality of the well-established German practice of executing civilian hostages in the form of reprisals for armed attacks launched by the Greek partisans. Anyway, let us move now to the next slide and the quest for justice, the domestic framework. Greece implemented domestically the internationally assumed obligations we have discussed about in the previous slides to prosecute and punish war criminals by adopting, first and foremost, Emergency Law 384 of 1945, establishing the Greek National War Crimes Bureau, the Εθνικό Γραφείο Εγκλημάτων Πολέμου, commonly referred to as the Bureau for the Prosecution of War Crimes, or the War Crimes Bureau. We're going to refer to it for short as WCB. As provided by the foundational instrument, WCB was supposed to act as both a war crimes reporting and investigation unit and a prosecutorial agency. The WCB consisted of a central service in Athens and local branches functioning in major cities throughout Greece, where courts of first instance were also seated. Although emergency law provided for sufficient staffing of the central service, basically 1 director, 12 assistants, 12 officers, 2 typists, and 1 messenger, but no translator, the service remained highly understaffed through the course of its brief life. Indicatively, the service acquired neither one of the 2 typists nor a translator. Given the particularities of its mandate, preparing case files and indicting war criminals was not an easy task per se, let alone trying to do so without secretariat and logistic assistance and without translators. The WCB was also responsible for the prosecution of war crimes based on the principles of territoriality, the loci delicti commissii, crimes committed within the Greek territory, and passive personality, crimes committed abroad against Greek nationals. The legal framework for the prosecution of war crimes was set in a series of legal instruments. This is, let's say, a well-established tradition in Greek legislative policy. We need more than 1 law. So we have Emergency Law 384, we have the Constitutive Act 73 of 1945, and which was amended by the Constitutive Act 90 of 1945. The legal framework was basically based on Article 6 of the IMT chapter and provided for the prosecution of domestic breaches of criminal law and the military criminal code, and what was referred to as violations of the international law of war. Let us now check these violations. As war crimes under the international law, the applicable provisions defined based on indicative enumeration acts including murder, systematic terrorism, torture, death by starvation, displacement or deportation, unjustified or inhuman deprivation of liberty, forced labor to the benefit of the enemy, forced conscription and forceful transfer abroad to provide services to the enemy, attempt to uproot the national allegiance of the population or alter the demographics of the population in the occupied zones, confiscation, forceful or malicious usurpation of private property, execution of hostages, armed reprisals against the civilian population, collective penalties, forced prosecution. The list contained a number of acts regarding the use of unlawful means and methods of warfare too, including crimes affecting national currency, crimes regarding the usurpation of the occupied country's sovereignty, and so on. The list was not perfect in any sense, but the indicative enumeration of acts would supposedly give the opportunity to the judicial authorities to interpret and apply customary international criminal law based on the principles established during the Nuremberg process, the Nuremberg trial. Moreover, it is important to point out that forced prostitution and civilian reprisals were included in the enumeration, enabling the prosecutorial authorities to deal with gender-related violence in atrocity context, although back then international law, and especially international criminal law, was not considered particularly gender sensitive. Let us now move to our next slide. So, Constitutive Act 6 of 1945 completed the domestic framework, penalizing a vast range of collaborationist activities, the so-called activities of those syllogismos, including the formation of a puppet government, the procurement of services to such a government, espionage and treason against the national interest during the occupation, excessive and unjustified enrichment, excessive and unjustified, due to the collaboration with the enemy and the puppet government, participation in paramilitary groups serving the enemy, and so on. The legal framework for the prosecution of local collaborators was one of the most concise and comprehensive attempts. Can you please close the microphone? To punish treacherous activities in continental Europe. It covered almost all areas of collaborationism, including political collaborationism, collaboration with the enemy to establish a political order, economic and financial collaborationism, collaboration with the enemy to achieve unlawful or unjust enrichment, and military collaborationism, the establishment and operation of enemy-controlled paramilitary units, which were notorious for their atrocity crimes during Greece's occupation. The puppet government of the so-called Hellenic state, this is the entity created by the occupying power to administer the civilian affairs of occupied Greece, established the so-called security battalions, διευζωνικά τάγματα or τάγματα ασφαλείας, per law 260 of 1943. The numbers of the security battalions were particularly, the members of the security battalions were particularly despised by certain, let's say, sections of the local population. They received a generous stipend and food rations from the enemy forces, and they were supported in terms of logistics and operations by the German forces. Being themselves ultra-rightists, members of the security battalions were known for their practice to publicly denounce civilians as communists or partisans, or threatening to do so to achieve personal gains, settle personal feuds, and basically try to force their own justice, especially in the countryside. For instance, the purging operation of Meligalas, we all know that unfortunate event, that atrocity, happened in 1943. It led to the execution of a significant number of the security battalion's men and civilian sympathizers. This page remains a dark page in Greek collective memory, given the fact that both paratroopers of the battalions and civilians were targeted with extrajudicial executions by the partisans. However, this was something that happened because both the security battalions, the Tagmatos Asfalias, and the partisans were basically preparing to wage a civil war upon the final year of Greece's occupation. Anyway, let us now move to our next slide. Greece, during the early years following the end of the Second World War and national liberation, tried to implement a set of principles, norms, and mechanisms promoting a rudimentary idea of transitional justice, to form a remedial and retributive justice mechanism, and to sufficient safeguard the transition of the state and national society to the post-war era. So war criminals were to be prosecuted and punished, local collaborators were to be legally and politically consent, civil liberties were to be restored. The rising tensions of the Cold War and the communist orientation of the partisan forces, not all of them, but most of them, The National Liberation Front, the so-called DEAM, which basically continued fighting the Nazis in Greece and administering civilian affairs alongside other organizations in liberated territories, while the official Greek government was in exile and it was relocated in Cairo. This whole situation created an explosive mixture of anti-communism, imposed amnesia, and Cold War bifurcation. Greek collaborationists were more or less utilized by the Athens royalist government and the British forces to fight the communist armed groups during the Civil War, which followed shortly after the end of the Second World War. Greek communities, especially in pre-war metropolis, with strong Jewish presence like Thessaloniki in northern Greece, Larissa in Thessaly, Ioannina in Epirus, were facing the shadows of collective guilt. This is something that we need to point out. With a population having assisted by acts or omissions in termination of the Greek Jews in the German death camps. So many prominent members of the local communities had closely worked with the German authorities to usurp and liquidate Jewish properties. They were obviously unwilling to account for their actions or to return the illegally expropriated properties. Acting as a custodian of an abandoned Jewish property, as was the legal term based on the decrees of the German administration and the laws of the puppet government, which were not abolished directly after the liberation, of course, was not considered prima facie a criminal act of collaborationism. And as will be shown in the case of Max Merton, the former civilian administrator of occupied Thessaloniki, even the gravest and most blatant violations of fundamental rights of the Greek Jewish population were never properly punished or addressed. The red line drawn between royalists and communists due to the Civil War contaminated the interest of justice with political exigencies and considerations, and created an overall tendency to penalize the participation in the National Liberation Front and whitewash collaborationists' crimes, given their ultra-rightist political affiliation. Finally, the Greek government was not very eager to pressure either the Allies or Eastern Germany to extradite alleged war criminals, and at some point, the local political elites even ceded Greece's primary criminal jurisdiction based on territoriality to Western Germany, as will be shown in the following slides. The WCB's first task was to scrutinize the report of the United Nations War Crimes Commission, a commission of inquiry and documentation that the Allies created in 1943. The indexes of the War Crimes Commission contained the names of almost 1,127 Germans, 470 Italians, 242 Bulgarians, and 410 Albanians who were allegedly involved in the perpetration of war crimes in Greece. Many of them were considered war criminals of inter-allied interest. For instance, Alexander Lea, the Luftwaffe, German Air Force, that is, commander, who was appointed commander-in-chief of the notorious Army Group E, conducting anti-partisan operations all through the southern part of the Balkan Peninsula, never reached Greece to stand trial, even though he was directly responsible for outrages and atrocities all over the country. For instance, he gave the order to execute 50 Greek civilians for every German soldier killed by the partisans, while he sanctioned the mass execution of 5,000 prisoners of war in the island of Cephalonia. The British authorities extradited Lea to Yugoslavia to force judgment for the bombardment of Belgrade, the anti-partisan offensives, and atrocity crimes against civilian communities. Of course, he was found guilty and sentenced to death in 1947. Other war criminals connected to Greece were already dead before the establishment of the WCB. So, let us now check justice in numbers. Some of you, I know,
Dimitri, I'm sorry for the interruption. We are actually running out of time. I have sent you several messages. Please conclude within the following couple of minutes.
Yes. I will conclude. So, between 1945 and 1949, only 17 cases were prosecuted by the WCB, from which only 3 were completed, leading to the imposition of the death penalty for atrocity crimes committed in Crete and Macedonia. Between 1949 and 1950, 7 additional cases were prosecuted by the WCB, reaching a total of 24 cases of war criminals prosecuted before the special court-martials. We have, let's say, the trial against Bruno Brauer, we have Friedrich Wilhelm Müller, and we also have the case of Fritz Schubert. Unfortunately, I'm not able to discuss the case of Max Merton, so let us now turn to the conclusion of the presentation. Of course, you know, we have open wounds. We have still open wounds from this transition. Of course, we have a standing issue on reparations, the forced loan, the looted treasure, the cultural treasures. Of course, we have several, let's say, attempts from Greek governments of the past to address the issue. However, we have, let's say, a problem discussing this issue and entering negotiations with Germany. We all know the legal context of the situation, and we are facing, or we may face, the legacy of this truncated transition and in the revitalization of political and ideological descendants of Greek Nazi collaborators like Golden Dawn, which has been declared, of course, a criminal organization during October 2020. Anyway, thank you for being here. Thank you for your patience. I hope this was interesting, and I'm looking forward to hearing your questions, observations, etc. I will now stop sharing my presentation.
So thank you very much, Dimitrios, for your great presentation. It was a very interesting one, since you have managed to introduce us to the analytical frameworks of transitional justice, presenting various cases that derive from the Greek post-war period. We're gonna start taking questions now, so please raise your hands. Let me just see the... Yes.
Andreas.
Yes, Andreas. So let's just start with the head of the Department of Political Governance, Professor Andreas Stefanos. Andreas, you have the floor.
Congratulations, Dimitrios, for your presentation. I have two related questions. What prompted you to undertake this research, this topic? And second, I had some friends in Greece from Thessaloniki that we discussed this issue several times in relation to the Nazi atrocities against the Jews. And when I saw my Greek friends, I remember at the university talking, I was not clear whether how did the Greeks saw this German atrocity. Were they supportive of the Jews, or did they turn a blind eye? That was a discussion that we had at the University of Pennsylvania, the Hellenic Society. And I want your perceptions as, not perceptions, your finding as a researcher, on this topic. Thank you.
Thank you for these interesting questions, and thank you for hosting this presentation or this seminar, Professor Stefanos. Well, regarding what prompted me to undertake the research, as you may know, I have studied jurisdictional immunities in my LLM. Basically, the topic of my LLM thesis, I'm extremely glad because Professor Dr. Miltiadis Arianidis is here, and he is, of course, I'll say, the supervisor of both my PhD and my LLM thesis. It was about jurisdictional immunities in the time of global constitutionalism, basically about hierarchy and constitutionalization in the international arena, and the so-called atrocity crimes exception vis-a-vis jurisdictional immunities. We all know that Germany utilizes this, let's say, prerogative of international law, of classic Westphalian voluntarist international law, in order to avoid, let's say, civil litigations from victims and victimized communities. I was also a lawyer, a practicing lawyer, on a pro bono basis, of course, for victimized communities in Thessaly and basically all over Greece. And I was a national expert at the Inter-Party Parliamentary Committee on World War II reparations during 2015 and 2016. So I had, let's say, the background, I have the primary sources, and I was also a student of transitional justice in the national criminal law. I'm studying genocide and the legal rights of victims to a remedy in the context of genocide. So I wanted to see if those doctrines, these doctrines discussed in terms of transitional justice can be applied in the Greek case. And according to my understanding, they can. Let us now turn to the second substantial question about let's say, what the Greeks did during the war vis-a-vis the Jews. Well, according to my understanding and according to my research, we have a firmly established national mythology vis-a-vis what the Greek population did regarding the Jews. We helped the Jews. We didn't profit, we didn't, let's say, benefited out from the liquidation of the Jews. in the death camps of Poland or other places, and we were supportive of the Jewish cause. No, basically, this is not true. Basically, we have several, let's say, depositions and testimonies from several survivors of the Holocaust death camps, specifically mentioning that if someone had opened his door or his cellar, my family would have lived. When they turned back to Thessalonica, for instance, you know, in Ladino, coming back from Auschwitz to Thessalonica is described as retorno all'infierno. So coming back from one hell to another hell. So when the Jewish community of Thessaloniki, the fragments of the Jewish community of Thessaloniki came back, they had to face not only concentrated amnesia regarding the private property of the Jewish community, but also they were facing basically not only boycott, but also attempts to penalize their vindication of their property. Let me, for instance, point out that when they have recognized the chandelier of a very, very old synagogue in Thessalonica, and they went to the church, to the Greek Orthodox church that had appropriated illicitly as a war crime this chandelier, and they asked for the chandelier not to be given back free, but to be repurchased. Several newspapers in Thessalonica thought about an organized attempt from the infidel Jewish community of Thessalonica, or what remained from it, to steal this. Another example, we have, let's say, an ultranationalist named George Poulos. He was member of the security battalions. He had a battalion baptized or named after himself, the so-called Poulos Verband. He basically brought to ashes Ermakia, a village in Ptolemaida, with Slavophones, with local Slavophone population, and he was particularly active all over Macedonia. Poulos was designated as, let's say, the Treuhander, as the custodian of the best jewelry shop in Thessalonica. This was, and we need to remember who was the real, let's say, proprietor, the jewelry shop of Isaac and Robert Botton. He basically used all the jewelry there and all the capital stored there in order to finance anti-partisan, anti-Greek operations. And suffice it to say that the Aristotle University of Thessaloniki has illicitly appropriated the oldest cemetery in the Balkans, the ancient cemetery of the Jews of Thessalonica. And this is something that we all know, but we avoid to discuss.
Thank you very much.
Thank you, Dimitri.
Let's just move now to Professor Sarianidis. Professor, you may unmute your microphone and ask your question.
Dimitri, thank you very much for your presentation. It always takes time with you in order to go fully through your presentation. But even in this way, we had the chance to listen to interesting things. My question is why you have actually chosen to apply transitional justice as a methodology in order to explain war crimes in Greece, both from the part of the tripartite occupation powers and, of course, during the civil war. Why I'm asking this? It is obvious that transitional justice is something that it is, let us say, a young science. It is not as old as international criminal law, for example, which is not quite old, but still it is older compared to transitional justice. And it is my conviction that we cannot actually talk about transitional justice during 40s, 50s, 60s, etc. So do you believe that is it useful to draw conclusions and improve our methodologies and research even better methods to do away with transitional justice by using as examples, as a roadmap, what happened, for example, in Greece during occupation years and during the Civil War?
As I have been told by you, Professor, as you terminology is very, very important. However, substance is far more important. So yes, transitional justice as a separate, let's say, sector of international criminal law or an intersection between international criminal law and human rights law is a child of the 1970s, the Inter-American Court of Human Rights, perhaps, or even several, let's say, social scientists trying to stipulate a few points about law and justice in societies under democratic transition. However, the basic aims, the basic goals of transitional justice are basically very ancient. This is the reason why I was mumbling about Hugo Grotius, Alberico Gentili, and Francisco de Vitoria. What transitional justice stands for today was more or less present, mutatis mutandis, during the early years of international law. And basically, what the so-called lex pacificatoria, the jus victoriae, and so on, wanted to do is to moderate the transition from of the civil polities of the commonwealths and basically of the peoples from one state to another. And we need to point out that according to recent TJ theory, even the Nuremberg process needs to be considered the very, very first mechanism of transitional justice. So if the Nuremberg process has this effect, especially as an institutionalized and organized narrative about the past, because transitional justice is also about dealing with the past, then we might have to, let's say, inspect, examine, explicate, or even suggest that transitional justice has to do something with post-war atrocities in Greece. And basically, this is something that I couldn't, let's say, erase. According to my understanding, this transition has been truncated and prolonged. Greek society unable to address justice during, let's say, the early after-war years and living in turbulent constitutional and political times all through, let's say, the best part of the 50s and the 60s, attempted after the Metapolitefsi, after the 1975 change of regime, not to address justice per se, but basically to, let's say, fill in some gaps in terms of equality, protection, and legal terminology. So the open wounds of today are connected to these early years. And even though transitional justice might, according to, let's say, the strictest view, might have nothing to do with early post-war years, it definitely has something to do with 1,500 victimized communities in Greece vindicating their rights today and needing, they are in dire need of self-authorship, of justice and reparation. This is not different from Namibia, not different from Rwanda, not different from South Africa. And several scholars of TJ discussing, let's say, the concept of transitional justice in terms of the early post-war years point out that the basic necessities, the basic needs are still the same.
Okay, thank you very much. Let's just go now to the Dean of the School of Law, Professor Milanides. Let me just...
Thank you, Andreas. Thank you, Dimitris, for this presentation. Before I ask my question, if I might begin with two technical comments, which I think this type of feedback is also useful in this context of research seminars. I think it would be very beneficial for future presentations of your work if you try to structure the replies to your research questions a bit more coherently. I have a feeling you had too many research questions, too much information, which does not directly lead to a specific research question being answered. I think for similar type of presentations, it would be very useful if you can, because I think for a minute I was feeling I was in Spider-Man 3. I don't know if you have seen the movie. Too many plots going on at the same time, too many supervillains to face. So I think that would be very helpful if you try to narrow down specifically. I have a research question. This is my answer, rather than to, you know, this felt sometimes more like a full class on transitional justice, carrying all the various characteristics, whereas you could narrow it down. I think it would be more helpful to us as audience. Also, I would advise you for future presentations to try to tone a bit the way you are talking. I think because you had to cover a lot of material, you were talking at times too fast. And so when you are giving to audience who are not necessarily familiar with the subject matter so much information, it's very helpful to pace your replies so that they can follow you. You are talking to people and you expect them to follow your arguments through. So these are technical characteristics, as I said. Now, on a more substantial question, I found your presentation very interesting. I am not so much against personally applying traditional justice to pre-periods. I am aware, for instance, of Christopher Warren's work on restoration, England, and so on. So this is something that is, let's put it in the international trend. I'm not against it. What I would be interested, however, to appreciate is the following. How do you view the relationship between transitional justice on the one hand, justice, and history? In the sense that history, and you are referring to historical facts here, history by definition is a discipline that is subject to narratives. It has various competing narratives that, well, none of them can be defined by force to be the correct one, let's put it that way, or the authoritative one, unless, of course, the political power at a given time declares it as such. But justice in principle, as opposed to law, justice has a feeling of authoritativeness, in the sense that there is a court. It might be wrong, it might not be wrong, but it has the authority to declare that some facts, and even some historical facts, have happened in a specific way or not. And we have seen this many times in court decisions, and that was part of your analysis. So considering this different agenda of history and justice, I would like to see how you cope with the challenges of dealing with these two differing concepts.
First, thank you, Dean, for your feedback. It's always nice to have, let's say, your advice on both technical and substantial issues, of course. Well, turning now to this very, very important question. This is, let's say, a core challenge of dealing with historical events under the lens of social sciences or transitional justice or international law in general. My understanding is that we do not need, in terms of transitional justice, to create an authoritative narrative. This is the reason why transitional justice has utilized both several hybrid, let's say, institutions and institutions of collective, forming, let's say, concurring collective narratives without establishing an authoritative one, like the Gacaca courts, for instance, in Rwanda. They were clan courts where mediation, dispute mediation, and also criminal mediation were exercised. In terms of the Greek case and what I'm discussing now, we have two strings of, let's say, we have two strings of history. The first historic narrative is the so-called national mythology. This is a narrative that has been let's say, established as the core narrative since the 50s, the 60s, and especially the 70s about what the Greeks did or didn't do in terms during the occupation. For instance, they were bearing their cross regarding the occupation, but they were not sympathizers. This is not true, based on research that has been conducted not by that or a Greek historian, but by or the other one. You know that sometimes politics and history play together, especially in Greek historians, but by several researchers and by several primary sources confirming, let's say, these statements. For instance, Katerina Kralova has done an excellent work. Of course, Hagen Fleischer and Mark Mazauer have done an excellent work documenting that this was not the case. The other part of the national mythology, for instance, is what happened with the Greek Jews and how bystandism and collaborationism basically paved the way to their liquidation in the death camps. So this narrative is plain and simple wrong because because a more modern research proves that something else has happened. In terms of the Civil War, where we can have a million narratives, this is not something that I'm willing to touch upon. This is something that I consider needs a specific institution of transitional justice. This is a Truth and Reconciliation Commission, because the dichotomies and the bipolarism that permeates Greek society, according to my understanding, and hopefully, and it's not just my understanding, is something that has to do with the open wounds of the Civil War period. However, in terms of transitional justice in occupied Greece, and regarding war crime atrocities, the narratives are not that important. Victims have, let's say, to present their case before a court. But if the state steps into this situation, if the state espouses the claims of the victims, then it's not about historic narrative. It's not about, let's say, transitioning from one court to another, but it's about a cause, say, relocated to the international or the interstate arena. So basically, it's something that I need to, let's say, study. I'm not prepared to answer this question definitely. However, I think that conflicting narratives in terms, for instance, of war crime atrocities in occupied Greece are more or less settled. And those narratives that have been established as national mythology need to be watered down and need to be scrutinized because they are not true. This is not something that's good for Greeks or this is not something that can make us proud, of course.
So, yeah.
Ask a question, sorry.
Yes, of course. After Stelios. Stelios, you may ask your question, please.
Oh, thank you very much, and especially thank you very much, Dimitrios, for the rich presentation. I would like to have your view on some thoughts of mine. Well, I'm not a very proficient connoisseur of the transitional justice literature, but to my knowing, transitional justice revolves mostly around claims to be met and things to be done within a national political entity, vis-à-vis the restoration of national legality, the national social bond, etc., and not that much in regards to claims towards another political entity, another nation state. As I see, your research moves in both directions and both levels. As far as, for instance, the dealing with the collaborationist problem is to be done, and as far as, for instance, revendications and claims towards Germany. Okay, my leading question vis-à-vis this research would be, how do you deal with these two levels, more especially Are the transitional justice postulates different in these levels? Are there any different criteria or aspects on the one level and the other level? And an additional question, if I may, another point that transitional justice theorists make is the peace versus justice debate. They keep saying that in sometimes we need to put aside the, let's say, I do not share this view, strict retributivist claims of justice in order to revendicate, let's say, reconciliation or peace. How do you deal with that, if you can answer within this frameworks? I know it's a big conversation. Thank you very much.
And of course, I had 3 slides about that. Well, anyway, that's my fault, basically. So, first, transitional justice in its original phase had to do with war atrocities inflicted by other nations, of course, aggression, within the national legal order and the national socio-political sphere, of course. And the second phase during the 1970s and since 1989 and onwards was about the national legal order, because we had a regime, both in Latin American countries and in former USSR satellite countries, we had a regime that allegedly committed several atrocity crimes and flagrant breaches of fundamental freedoms against the local population. In terms of Greece, we might as well discuss transitional justice after the end of the civil war, but that's not the case. We are discussing, or we are focusing on war crime atrocities committed during the tripartite occupation. There, transitional justice has, of course, moves in 2 levels. In the national level, it has to do with the inability and the unwillingness of the Greek state for over 70 years to address these questions in terms of law and in terms of policy. I had a slide, of course, about the violation, the breaching of legal obligations assumed by Greece vis-à-vis its national population and the allied countries regarding the prosecution and punishment of both German or Nazi, let's say, perpetrators and local collaborationists. Greek failed these obligations, failed the St. James Declaration. Greek failed even the European Convention on Human Rights, which was adopted, which was accepted, and adhered to during the 50s. Of course, we have the Yanovich precedent. The European Convention on Human Rights cannot be applied per se on war crimes and wartime atrocities. However, there is a residual argument regarding the so-called obligations owed by the state to its own citizens based on the human rights inscribed, recorded, documented in the European Convention on Human Rights. Of course, Greece has also violated its 1952 constitution, because we have several laws imposing an institutionalized amnesia, dismantling the WCB as an act of mere revenge, because Mr. Toussis, the head of the WCB, prosecuted the case of Max Merton, despite the best advice given by both Germany, Western Germany, of course, and the Greek government, and the best pressure exercised towards this goal. So, transitional justice in terms of national society has to do with what the Greek state has failed to do for the last 70 years. Transitional justice in the international level, if you like that, has to do with the opportunity and the power given to Germany, to the reunified Germany, of course, to deal with the past. Basically, Germans were the very first to coin the term DWP, dealing with the past, which is part and parcel of nowadays TJ doctrine. However, Germany dealt with the past slightly unilaterally, of course, and it also failed to deal with the past regarding states not signatories to the 2+4 treaty on the reunification of Germany. But this is another story and another discussion for another day.
Thank you very much, Dimitrios. Let's just go now to Farid and Hubert, who will ask the 2 last questions of today's event. Farid, you may ask your question first.
Thank you very much. Thank you for the presentation. My question kind of repeats what Achilleus the Dean asked you. I just take it a step further. I'm sorry I missed the first few minutes of your presentation, so my question therefore may be redundant, for which I apologize. But I have to ask it, what is your specific research question? I mean, if I understand, is a PhD, if I'm not mistaken?
No, this is not my PhD.
This is not your PhD. Okay. Well, that somewhat changes it. But what is it you are looking at, and what findings have you? I know you were short of time, and you had to cut short at the end. But what answers have you come up with for the research question that you have? Is it just a narrative that this and that happened and justice was not restored and therefore it may happen again? And you're substantiating, you're filling in the gaps with data and figures? Or what is it that you're asking, and what is it that you found?
Okay, basically.
So, excuse me, just a moment. Excuse me for a moment. Let's just go to Huber, who's going to ask the very last question of today's event. Huber, you have the floor.
Okay, Dimitrios. Well, congratulations to a nice presentation, and please don't misunderstand what I say at the next couple of seconds. An apologetic attempt by a German to downplay the German atrocities in Greece, which I have no intention of denying. But I wanted to point out that you have a gap in your literature. The great opponent of Hagen Fleischer is Heinz Richter, who's also informing the German governmental positions on the Greek claims. And he at least claims in his work that there were 2 additional payments to Greece that were either embezzled or never arrived. He also claims that the money Germany forced out of Greece was more than compensated by money Germany gave to stabilize the Greek drachma. I'm not telling you that you have to agree with this, but I'm telling you that you have to engage with this. So that's just a hint on a gap that I saw in your presentation, because you have Hagen Fleischer, and Richter used the same document than Hagen Fleischer and claims a couple of pages down you have the loan of Germany that in a way equalizes this, culminating that Greece even owes Germany money, which is of course outrageous if you're Greek to listen to. But in academia, you have to engage with it and debunk it, and say this is either nonsense or the historical evidence is not credible or whatever. So I just wanted to point that out in order to close the gap there. Just a little addition to Andreas' question, but I try to be brief. I edited a book in which there's an article about the destruction of the Jewish cemetery in Thessaloniki by a Greek scholar of Jewish descent, Leon Saltiel. Yeah, Leon Saltiel, who points out that the Greeks were actually the driving force behind the destruction of the cemetery. And just to come back to Richter again, Richter is in great disagreement with Saltiel on the role of Mertens, because Richter claims to have evidence that Mertens was actually protecting the Jews. So while he's seen as the great culprit, that there's a distortion of history, and he's not a pro-Nazi apologist. He's one of the leading historians of Greece. But I just wanted to tell you that there's additional information there that you might find of him.
I have extensively annotated the case against Professor Richter, and of course I know his work. It was, of course, I omitted, let's say, incorporating his title in the seminal volumes, let's say, section, and this is something. This is a fair point. Regarding the, let's say, the battle between Nassauer or Hagen Fleischer, to be exact, and Richter, I'm not in a position to argue something because I need to, let's say, address Professor Farah's question too. This is an early stage for a discussion of my research. This is a research that I have started only in January. However, I gladly accepted this invitation because it was an invitation to present even the preliminary, let's say, at the preliminary stage of my research. And I selected this research and not my PhD research because I wanted to get feedback regarding this question that might be turned into a postdoc, for instance. So, turning now to the substantial questions regarding, for instance, the narrative about the Greek Jews. According to my understanding and according to my research, of course, I'm waiting for several documents to be digitalized in order to form, let's say, an opinion based on primary and not on secondary sources, but this is something else. The Greek the question of the cemetery, of the Jewish cemetery in Thessaloniki, was a fair combination between Max Merton's willingness to instrumentalize friction between the two communities, the Greek community and the Jewish community, to the benefit of the occupying forces, of course. And it was something that happened directly before the application of the Nuremberg laws against the Jewish community of Thessaloniki. So it might be a prelude. It might be, let's say, the culmination of frictions in order to pave the way for something else. But this is something that remains to be seen, and this is something that not even Professor Fleischer says basically about Max Merton. And the second point is that basically, if it weren't for the Greeks demanding the uprooting of the cemetery because it was at the center of the city, Max Merton would not be able to instrumentalize the question or to, let's say, try to protect, in inverted commas, the Jews of Thessalonica. I will trust in this Mr. Kourtis and the WCB archives. Of course, we have only secondary narratives about the archives, fairly consolidating the indictment against Max Merton regarding the mass murder of the Jewish community of Thessalonica.
Okay, so thank you very much, Dimitri. This concludes today's event. I would like to thank Dimitrios